What justification can there be to have over 600 cases as pre-election cases which INEC has been joined? For those who are very quick at pointing accusing fingers at the courts and saying that they have an overbearing effect on the results of our elections and on our democracy, this is the time for such group of people to draw closer to the political parties and tell them to play by the rules. Because it is the lack of playing by the rules that force courts to nullify any elections, even after people have determined who they want to vote for. The elections have to be done by the rules, just as it is expected that the primaries of all political parties must comply with the rules of both the parties and the Electoral Act. The Chief Justice of Nigeria has inaugurated the various tribunals that would be determining the results of elections if there are complaints about those results. Of course, we look forward to the day when a tribunal will sit in a state and have no cases before it. That is because the parties would have accepted the result of the elections, or the parties would have determined by themselves that this election was conducted in a free, fair, and transparent manner. We're waiting for such a day. But then the judiciary is part of our democracy, so it must determine any case that comes before it. The Chief Justice of Nigeria, Justice Olukayode Ariwola, has constituted all the tribunals. And that is what we are going to start the scale with on this program. Welcome to the Scale of Justice. I am Femi Okeowo.
Imagine any society without laws. Imagine piles of laws without the courts to interpret them. Imagine lots of interpretation without a medium to bring them to your doorsteps. The Scale on the network service of the Nigerian Television Authority helps to fill the gaps and turns law and justice into a tangible instrument for national development. That is the Scale, and it is balance.
Normally, these tribunals are constituted at the headquarters of the Court of Appeal, which has that under its jurisdiction. But the number is so much this time that they had to shift venue to the National Judicial Institute. That is where the panels of courts that would be determining the result of the next year's election have been constituted. Dele Atumbi is our guide in that segment.
The 307 judicial officers are the ones to be empaneled as members of the National Assembly House of Assembly and Governorship Election Petition Tribunals for the 2023 General Election. Section 285 subsections 1 and 2 provide for the establishment of the tribunals to determine the validity or otherwise of the elections of candidates for the offices in the National Assembly, House of Assembly, and Governor of any state. These tribunals served as trial court and their decisions are subject to appeal. Administering the oath of office on the judicial officers, the Chief Justice of Nigeria, Justice Olukayode Aruwola, urged them to be upright in all their decisions. Both the Chief Justice of Nigeria and the President of the Court of Appeal charged the judicial officers to protect the integrity of the judiciary in all their decisions as they uphold the truth and dispense justice accordingly.
So help me God. So help me God. I can confidently tell you that this is a weighty undertaking you have just signed before the Almighty God. I am saying this because, as the Chief Justice of Nigeria, I will not condone any act of recklessness, abuse of power, and public trust. This is a real privilege, and your lordships must give a good account of yourselves. Your lordships should count yourselves worthy to be so entrusted with this humongous responsibility of deciding the fate of those that will be contesting elections into various political offices in the country in year 2023. Though judicial officers are not known to possess some supernatural powers to perform wonders, I can confidently assure you that the society that we live in will certainly expect the impossible from you as members of election petition tribunals. There is virtually nothing that has not been seen or heard before, but you should be ready to see and hear more, especially as you begin to adjudicate on election matters in 2023. Even though I rejoice with you on this very important appointment, I still sympathize with you for the many troubles, inconveniences, verbal assaults, and all sorts of uncomplimentary remarks that will be made about you by various litigants in the course of your adjudication, especially if your conscience is not controlling your conduct. We are all humans, no doubt, but you display the humanism in you by doing those extraordinary things that people will ordinarily say you cannot do. That is what distinguishes you, those with integrity and passion for success, from those with an enviable pedigree and dysfunctional moral compass. Trust is a burden, and you must discharge it with utmost sincerity, honesty, and transparency, because conscience is an open wound healed only by truth.
Section 130, sub 3A and B of the Electoral Act states that election petition tribunals shall be constituted not later than 30 days before the election, and the registry of each tribunal must be open for business 7 days before the commencement of the election. This compelling constitutional mandate is one we take with utter awe and dutiful compliance. The assignment is awesome and humongous. The heads of court of all the jurisdictions in Nigeria had since been requested to carefully select judges of tested experience and integrity to participate in the national assignment. Your lordships must count yourselves worthy to be entrusted with the responsibility of deciding the fate of those who would be contesting for political offices in the various states of our great nation, and who will assume the mantle of leadership of our great people in the next 4 years. Your various heads of court have expressed their trust and confidence in your credibility competence, and integrity. The Nigerian Bar Association at its different branches have also acceded to your suitability before your nominations were accepted. I hope that you will each uphold the trust reposed in you and the discharge of your duties at the tribunals. Your lordships must not allow yourselves to be used as conduit pipes for evil machinations. You must stand up to your values and good conscience at all times. Your decisions must be based on your clear understanding of the facts and the law and application of the law that you swore to uphold upon your appointment. You are being reminded of that oath today by being sworn in once more by the Honorable Chief Justice of Nigeria for this specific assignment. By the nature of your office, all sorts of avarice will come your way. That is the nature of your assignment as judges of the tribunal, election tribunal. But you must be in total control of your courts and refuse to be used as tools to truncate the process.
To aid their assignment, the Court of Appeal produced a Judicial Electoral Manual 2022 containing decided cases on electoral matters. INEC Chairman Professor Mahmood Yakubu appealed to the judiciary to assist the country in deepening constitutional democracy.
The new Electoral Act confers exclusive jurisdiction to hear pre-election cases on the Federal High Court with regard to candidate nomination in order to reduce forum shopping by litigants, abuse of court process, and reduction in the spate of conflicting judgments by courts of coordinate jurisdiction.
Justices of the Court of Appeal are also in Abuja for their capacity building workshop. The Court of Appeal under the Nigerian law is the court of first instance regarding any question arising from the conduct of presidential election.
Let's hope and we look forward to the day when a tribunal will sit in a state or anywhere and will have no petitions before it. That would happen only if the participants in that election have agreed that that election is free, fair, and transparent enough and there's no need to petition, or that the rules have been applied and complied with by all the parties. We really look forward to such a day. Now, let's go to our Administration of Criminal Justice Act. Under the Ministry of Justice, there is a committee that is to ensure that the Administration of Criminal Justice Act is fully and well implemented in all parts of the country. Now, there are states that are just adopting the Administration of Criminal Justice Act, and there are states that have actually adopted it long before with modifications to suit their own state. Now, this committee has moved to the Oyo State capital, Ibadan, to scrutinize how the states under that zone have continued to implement the Administration of Criminal Justice Act. Here is a rundown of how the Ibadan workshop went and how these various states in this zone, Lagos, Ogun, Oyo, and others, have made sure that their own Administration of Criminal Justice Act is helping the dispensation of criminal justice in their state. The Ibadan workshop was attended by all the categories of justice sector workers. The opening session was also attended and addressed by top officials of the Federal Ministry of Justice and representatives of the Oyo State government being the hosts.
Oyo State being one of the federating units in Nigeria, so we as a state are hosting the Southwest workshop, and for us it's important because justice has to be seen to be fair, and the system has to be efficient to dispense justice fairly and efficiently. So this workshop is about how to improve on the management of the criminal justice in the Federation.
The administration of criminal justice is a very important aspect of justice administration in Nigeria. You know, we have the civil administration and the criminal administration. Administration of criminal justice also has to do with security and peace within the state. So it's very, very important and relevant to democratic governance, development, and progress in any nation. Interestingly, we have the administration of criminal justice law complementing existing laws like the criminal code and the criminal, penal code in being able to bring reforms into the areas that we have seen are problematic in the administration of criminal justice. Subsequently, the various states, as you've heard, up to 33 states now, have passed the criminal justice administration law, because administration of criminal justice is of concurrent jurisdiction to both the federal and the state governments.
Well, basically, those sections are about oversight by magistrates over police stations and other places of detention. The idea is to ensure protection of the rights of inmates and overstaying by inmates in any facility at all designated for detention. It's very important that we have this oversight so that there is no abuse by security and law enforcement agencies. So it's very critical that magistrates are aware of the provisions of this section and the powers given to them by legislature to oversight federal agencies in order to enhance the implementation of the criminal justice system generally. We hope that we can improve the capacities of magistrates in the southwest region to more effectively implement those sections, particularly in view of its effect on the fundamental rights of people who may have been detained by various security and law enforcement agencies. We set up justice sector reform teams. So this is a framework through which various justice sector committees meet, both federal and state, to compare and kind of peer review. How has it been? How is it going? What are the things we need to work more at? What are the areas we need to address? And perhaps even in terms of legislative amendment, what laws do we need to change to make it more effective? So there's that, and there's also this platform which we have just opened today, from where we can also take feedback from stakeholders.
Stakeholders in the implementation of the Administration of Criminal Justice Act include the police, all agencies empowered by law to arrest and detain suspects, judicial officers, magistrates, and prosecutors. What is the crux of the paper you delivered for the justice sector personnel in this zone?
Okay, we are here in Ibadan as a part of the continuation of our capacity building of agencies and institutions that are saddled with responsibility under the Administration of Criminal Justice Act. The paper I delivered is on the far-reaching reforms introduced by the Administration of Criminal Justice Act. And these far-reaching reforms talks about speedy dispensation of justice. We talked about provisions in the Administration of Criminal Justice Act that provide time protocols for adjournment of criminal cases. We talked about provisions that prohibit arrest in lieu, a situation where somebody commits an offense because that person is not found, his father, mother, and relations are arrested in lieu of him, and these people are innocent of the offense alleged, but because of their relationship with the suspect, they are arrested in place of the suspect. Section 7 of the Administration of Criminal Justice Act prohibits such arrest. Then we have provisions that talks about adjournment in criminal cases. With situations in the past where you have criminal matters adjourned, particularly where the arraignment is in the magistrate court over offenses that the magistrate court has no jurisdiction. Then the suspect is remanded and the case is adjourned to, in some cases, years, months passing without the suspect being arraigned before the court of competent jurisdiction that can try such matters. Such suspect ended up staying in custody over and above where they are staying in custody would have been if they were convicted of such offenses.
Since you're talking about this now, what does the Administration of Criminal Justice Act talk about holding charges?
Yes, the Administration of Criminal Justice Act has now provided time protocols for holding charges. In some states, it is 30 days. In some states, it is 21 days, depending on what the state law provides. But the ACJA provides 21 days in 3 instances. The first arraignment, if the investigating police officer has not concluded his investigation to enable him arraign the suspect before a court of competent jurisdiction, the magistrate will adjourn the matter for another 21 days to give time for the IPO to conclude its investigation. If on the second adjourned date, the IPO is still yet to conclude its investigation, the magistrate will now adjourn for another 21 days, which is the final adjournment on that matter. If on the third adjourned date, the IPO is still yet to conclude its investigation, the law provides that the suspect must be granted bail pending when the IPO is ready to arraign him before a court of competent jurisdiction.
Some criminal cases are prosecuted by the Ministry of Justice. You kept on talking about IPO. Is it in all cases that you have IPOs involved?
In all criminal cases, you are supposed to have an IPO involved. Because when a criminal matter is reported at the police station or in any security agencies, officers are designated to investigate that matter with a view to establishing a prima facie case against the suspect to enable them arraign the suspect. So in all criminal matters, there are supposed to be IPOs. That's the investigating police officer who is charged with the responsibility of investigating the offense alleged.
Each time we go on these sensitization workshops, you know I'm always very interested in feedbacks. What are the feedbacks from the states? Now you have Lagos, Oyo, and this zone. What are the kind of feedbacks you get in terms of the implementation of the Administration of Criminal Justice Act?
Yes, we have machinery that we have put in place for feedbacks. And we also have platforms that we have created for continuous interaction. When we build capacities of states like this, we put them into group. Each state is now grouped together, and we create a platform for them where they can interact among themselves and also interact with us. So when magistrates go on such visits, they put their findings on the platform, the WhatsApp platform that we have created for interaction and for sharing of experiences. So they share their experience and the outcomes of such visits on those platforms. Then it enables their colleagues to know what they have done and also to know best practice in the course of these oversight visits. And with that platform also offers the opportunity to also share with them. When we go through those platforms, their experiences and all, where we have suggestions, we make on the platform for the purpose of guiding them for a more effective service delivery.
Yes, that's a continuous effort to monitor and ensure that Administration of Criminal Justice Act, a legislation that is meant to guide the administration of criminal justice in Nigeria, is fully and well implemented in all parts of Nigeria. Thank you for being part of the scale today. More issues are rising daily as we inch closer to the 2023 general elections, and you can trust that you would find these issues being sorted out and being explained on the scale of justice. We'll see you again.